Thank you for being here this morning. It's a pleasure to be giving this presentation in such a nice place. It's usually relegated to some office block in Docklands in Melbourne or something like that, but this is much nicer. As you can see by the title of my presentation, I'm going to talk about Creative Commons and the licensing of the water data that you, certainly named persons under the Water Act, the Commonwealth Water Act, supply to the Bureau of Methodology. I might also touch on the right to information. What I mean by that is the Right to Information Act, which was brought into power in Queensland in June of this year. So just by way of a few contents, a bit of a background on how this whole thing concerning Creative Commons and what Creative Commons is kicked off, the benefits of adopting it, implementing the approach as the Bureau has seen fit, and the right to information. So, by way of background, the Water Act 2007 was enacted on the 3rd of March 2007 under the then Water Minister Malcolm Turnbull in the former government. It is a very powerful act. It was, as a lawyer looking at it, I think there was some contemplation in it that it might have been unconstitutional. Why do I think that? Because Parliament saw fit in a couple of sections to explain all the areas under the Constitution that they think that they can make an act like this. I think they had an idea that it was going to be a very powerful act, and they wanted to explain why it was that they think they had the power to enact such a piece of legislation. Now, it is powerful because with respect to the collection of water information, the director can collect any water information from whomever almost with unlimited power. Almost with unlimited power. Collection is unhindered. Collection can survive a reliance on something like a contract where you say, oh no, you can't have this as commercial in confidence. Section of the Act says, no, that's okay. This Act trumps commercial in confidence. There's even a provision in the legislation that says this Act trumps any power granted under any Act of a state or of the Commonwealth that might otherwise prevent the information from being supplied. Now, I can only assume that might be something like the Privacy Act. Something like that anyway. So, very strong powers of collection. But the Act also confers power on the director to publish certain bits of information. They're required to publish the National Water Account and a few other things like that. But they can only publish information where it doesn't personally identify someone, or if it does, as long as that information has already been made available somewhere else, or by negotiation with the relevant party that has supplied the information. So that's all fine and dandy, fairly straightforward. We understand that unhindered powers of collection, but certain powers of publication. Couched somewhere in the middle of the Act was a difficult section, and that's the one up there on the first dot point. Property rights in the information provided to the Bureau do not pass to the Bureau by virtue of Section 129. Now, I've interpreted the term property rights to mean inclusive of intellectual property rights. So, if there is intellectual property rights, i.e. copyright, in the water data, that remains the property of the named person supplying. It's not the property of the Bureau. The Bureau can publish it. They've got a statutory power to publish, which defeats the Copyright Act. They've got a statutory power to publish, but it's limited within the bounds of what can be published, and I think at the moment we're all concentrating on the National Water Account that's due out soon. So in that context then, you see where I'm approaching this from. This carries some significant consequences for how named persons supplying the information to the Bureau are going to manage downstream, as it were, the publishing of that information. we were engaged as the Queensland Government by the Bureau to look at this space because it was a rather interesting one. I can't think of any other Commonwealth Act that deals with something like this. And we were asked to examine what might be a reasonable solution for the licensing of water information if that's appropriate in the first place. And certainly it wasn't a given that the licensing regime would be necessary because there are 3 cases that are referred to generally in this country as authority for the proposition that there may or may not be intellectual property in water data. The first case is a United States case about 20 years ago concerning telephone books that said, no, the United States law doesn't recognise copyright in a compilation of numbers. Think water data, compilation of numbers. Because there's been no creative spark. And without creative spark, you can't say there's any novel about it. And so without novelty, there's no copyright in it. It's part of the corpus of human knowledge. 10 years fast forward back in 1990, Telstra were in court and technology had moved on. It was again about telephone books, but this time it was about reproducing them on a CD-ROM. And Telstra said, hang on a second, we've always had copyright in our telephone books. They're trying to put these numbers in a list on a CD-ROM. That's infringement of our copyright. And the full federal court in that case looked at probably about 120 years worth of Anglo-Australian jurisprudence on copyright. And came up with the position that, well, yeah, you've got to have creative spark and you've got to have some novelty. That's true. But you don't only need that. You can also have sweat of the brow. If you've gone out, like Telstra, and you've created an infrastructure, like Telstra, with computers like Telstra that record telephone numbers like Telstra, and you collate them into books and you distribute those all around, and that sweat of the brow is going to confer copyright on that information. Telstra went away and said, yay, fantastic, excellent, brilliant, we've still got a telephone book business. Until earlier this year, when another case was before the High Court called IceTV. I don't know if you've heard of it or not. It wasn't about telephone books at all. It was about electronic program guides for television. And the court there was concerned with what was a substantial infringement of a television program guide. Channel 10 and 9 and 7 had all joined forces against this IceTV organisation. The court held, incidentally, that it wasn't an infringement to copy an electronic copy from a television guide the name and time slot of a television program. Excellent. IceTV went away and said, yep, thanks, told you so. But what the court was also asked by friends of the court, there were some people there from Telstra, incidentally, the same lawyers that appeared with Telstra 10 years earlier in the full federal court, who said that, can you please tell us, once and for all, in the High Court, whether or not sweat of the brow is legitimate? Because we've got a case in the States that says it's not, we've got a case here that says it is. Clear it up for us. And this High Court, Justice Kirby actually had retired, so he wasn't sitting on this case, so there were 6 instead of 7 judges. All 6 of them turned around and said, we think the decision in Telstra 9 years ago might well have been wrong. Now, that's 6 judges speaking 10 years after the event. Judges aren't there forever. They retire. So if you come in another 10 years' time and you have another 6 judges, they might say something different. But we can't rely upon that decision because they said that in what we call in legal parlance as obiter. Something said by the way. It's not binding upon the court to say that. They're just expressing a view. So I say there is uncertainty concerning the subsistence of copyright and water information because of that case history. A bit like a microphone public speaking, I think though you always have to consider it live. And I think it's prudent to consider that there is copyright in your water information until we get another or a clearer definitive statement as to where it is. It's not only water information, by the way, it's almost any scientific data out of a database that is a reporting of facts that this issue applies to.